As I say.
My Lord, thank you. Just before I recommence my dive into the Court of Appeal, Lord Stevens asked me a question about treatment. Can I just give you my references? What treatment would he need? It's EF 402 through to 406. So, my Lord, EF 402 to 406, including 6.4.4, very robust. That's where robustness appears. He needs to have a robust package of care and support extending beyond EMDR, CBT, etc. And then on transition, my Lord, why end Uganda, that case I gave you, it's not just the rules, Mr. Cox reminds me, it's the rules and the Act. Commenced in July 2014, and with regard to the governing appellate provisions, I gave you the right answer for the wrong reason. I said they applied. I think I said it's because of the date of decision. That's not right. It's because they only commenced in April 2015, about a year later. And we can give you a note if you'd like on this, on commencement. So, then going back into the Court of Appeal, paragraph 63, Court of Appeal.
Have you got some way to go with this?
No. I'm going to be very quick. Paragraph 63, Secretary is right to point out that financial dependency and criminal convictions, if evaluated, may indicate a lack of integration. So what the court there is saying, that these are relevant factors. They're not mandatory relevant factors. They could be relevant on the facts. They're relevant in the Creed NZ public law sense of relevant, so that you can have regard to it. And if you don't, that is fine, unless it's perverse not to. That's Lord Cook in Creed NZ, endorsed in Re Findlay 1985 appeal cases 318 at 333H to 334. The court continues, but the tribunal was equally entitled to find facts about SC's traumatic history, the duration of his lawful residence, his attendance at school, his recent progress, and the family life he enjoyed here. So that is all they say relevant to cultural integration, and impliedly rejecting Mr. Malik's complaint in 58 that the FTT erroneously took into account SC's compassionate circumstances. They reject that. It's a relevant matter because, as Lord Justice Leggett has said, criminal offending can be a result or a cause of lack of integration. Here the finding was it was the result of great trauma, or at least partially so. Going back to 63, likewise the FTT's findings of fact about age he left Jamaica, the torture experienced, the need for specialist mental health therapy, relevant to very serious obstacles. That's pretty clear, we would respectfully submit, and putting it, understating it, if anything. 64, accordingly, as respects two of the factors relevant to exception 1. In fact, it's all of them now, because the court found in favour of the lawful residence limb. The FTT's findings of fact are not obviously perverse and would be relevant if evaluated by reference to the appropriate tests in the statutory scheme. That, we submit, is a reference back to the idea pressed by Mr. Malik that 117C2 is governing and not preambular. It can only mean you, the tribunal, should have balanced the public interest in deportation or weighed it when you were looking at both factors. Next sentence, that said, I accept that's a bit redundant, that said, I've come to the conclusion the FTT erred in law in the approach it adopted to the public interest question in its overall evaluation of the relevant facts. Now, that again, it's dealt with the safety net at paragraph 62. That again is that same idea that we know to be wrong from KO Nigeria, the idea that you weigh in the balance the public interest in deportation. The court at 65, Lord Justice Ryder, allowed the appeal on all grounds. This is interesting, and I'm going to finish very soon, because the grounds we have at 604, they are more, these were the grounds, they're set out more fully than Lord Justice Ryder at 27. You don't really get what's happening from paragraph 27. That's a summary. The actual grounds we have at 604, and we see in ground 2, that is paragraph 399A of the rules. That is the same as exception 1. And the Secretary of State says the tribunal misconstrued that provision. That can only mean it didn't balance or weigh the public interest. It can only mean that because the tribunal used the exact terms that Parliament said it should use, or the rules said it should use. Socially and culturally integrated, very serious obstacles to integration. So misconstrued that provision. That can only mean didn't balance. It goes back to Mr. Malik's argument I showed you before at 37 of his skeleton, EF622, and will make perverse findings. That was rejected. Perversity was rejected. We've seen that. It could if the appeal is being allowed on all grounds, it could only be in relation to ground 2, exception 1, that it misconstrued that provision. Because we see from ground 3, that's the safety net. The last thing I'm going to say, if I may, just going back to issue A, even if, my lords, my lady, you're against me on the relevance of internal relocation to Article 3, we'd respectfully submit it's very important that you nevertheless say, if you accede to my submission on issue A, that the Court of Appeal were wrong, because that ruling is being applied across the board. It is a construction, interpretation of Yanuzi, which is a refugee law case. That's the only thing I'd say about that now. But those are my submissions, unless there's anything else I can help you with.
Thank you very much indeed, Mr. Hussain. Oh, sorry. Yes, Mr. Malik.
Lords, milady, I propose to set out the Secretary of State's position as to the point that, my Lord, the President raised at the outset, and the objection that Miller and Trent took as to the inclusion in my written case of the appellant's recent offending. I will then address the court on the 4 issues in turn. And in doing so, I shall seek to focus on the submissions that Miller and Trent has made orally this morning. Lords, my lady, the Secretary of State conceded before the tribunals below that the approach in paragraph 3390 of the immigration rules applies also to Article 3 claim made by the appellant. And I respectfully recognize the force in the point that my Lord, the President, has made. And it may well be that the concession should not have been made and is more generous than the terms of Article 3 itself. But I do not seek to go beyond that concession. And this is essentially for two reasons. First, the concession is based on the Secretary of State's published policy. And I do not advance an argument before this court that is contrary to what the Secretary of State has said publicly about Article 3 in her policy documents. And secondly, given that the concession was made before the tribunals below and was maintained at the Court of Appeal level, it wouldn't be appropriate to seek to withdraw it at this very late stage. So I am, in the circumstances, content for the court to proceed on the basis that there is a concession and it's common ground that the approach in paragraph 3990 of the immigration rules applies to Article 3 as well, but perhaps without deciding the point in this case.
So just to be quite clear, it's a matter of concession that paragraph 3390 applies to the Article 3 assessment in the context of the deportation of a foreign criminal.
Yes.
That's very helpful, thank you.
My Lords, my lady, my learned friend took the objection to my inclusion of the appellant's recent offending in my written case. I'm not, I emphasize with respect, inviting the court to uphold the order made below on the basis of these recent offences. The ultimate question for this court is whether the first-year tribunal had erred in law in making its decision by reference to what was before it. In my written case, at the end, I think it's paragraph 92, I referred to an additional benefit of the remittal. And that benefit is that the first-year tribunal made its decision good 6 years ago. And at the rehearing, the first-year tribunal will be able to take account of the case law that was not available then, and will also be able to evaluate recent offending. And as my learned friend correctly pointed out, any fresh evidence that he seeks to adduce. But I'm not asking the court to uphold the order made by the court below if the court takes the view that the first-year tribunal had made no error of law in allowing the appellant's appeal. So may I now turn to the issues. First, issue A. My Lords, my lady, that issue concerns relevance, if any, of a person's criminal conduct to an assessment under paragraph 3390 of the immigration rules. My Lords and my lady have seen the provision. It reflects a well-settled and uncontroversial principle that a person who faces a real risk in one part of their country are not entitled to protection, whether it's under the Refugee Convention, the Qualification Directive, or the European Convention on Human Rights, if there is another part in their country of origin where there is no real risk of ill treatment and where they can reasonably be expected to relocate. What is reasonable in this context depends on all the circumstances and an evaluation of a range of factors. My case is that one of those factors is a person's criminal conduct. So a person's criminal conduct is relevant in deciding whether the test in paragraph 3390 of the immigration rules is in fact met. This is what I shall respectfully seek to persuade the court to find. The Court of Appeal said in its judgment at paragraphs 37 to 40, I'll take the court to those paragraphs. I emphasize with respect that it's not my case before this court that a person's criminal conduct is relevant to the standard of harshness for the purpose of paragraph 3990 of the immigration rules. I do not argue that a person's criminal background means that he should suffer more before their relocation is deemed as unreasonable. And I'm not inviting the court to hold that a criminal should tolerate harsh consequences to a greater degree simply because they are a criminal or because there is a public interest in their removal. I accept that the public interest has no role to play in this exercise. And I also accept that this exercise does not include a balancing exercise of the public interest in deportation of foreign criminals at one hand and the harshness caused by internal relocation on the other hand. In this particular context, I accept that public interest cannot render reasonable what would otherwise be an unreasonable expectation to internally relocate. But I do say that a person's criminal conduct may well shed a light on the robustness or strength of their personality and character. It can be relevant to their survival capacities. It may tell the decision makers something about their abilities to plan and organize, to interact with others, to make new links, and to develop relationships, and to adjust in difficult circumstances, and so on. I've given some further examples at paragraph 47 of my written case. So my submission is that criminal conduct is relevant in that sense alone to the question of whether a person can reasonably be expected to internally relocate. This means that there is no dispute between the parties as to the law on issue A. My learned friend categorically and correctly accepted in his submissions that criminal conduct and characteristics and history associated with it is relevant to whether the unduly harsh test or the reasonable test is in fact met. And I'm not asking the court to go further.
But you did put it more widely before the Court of Appeal.
Yes, and I will explain the reasons for that, my lord. But may I take, my lords and my lady, firstly to the Court of Appeal's judgment to see what the court actually decided, and will then very briefly respond to what my learned friend said about the two skeleton arguments that I had drafted for the Court of Appeal. So firstly, the Court of Appeal's judgment. That judgment, as lords know, is in the core volume, EF page 137. Now, my lords will see...
I'm sorry.
Yes.
Incidentally, just while we have page 137 in front of us, I see the date of the judgment was back in 2017. Is it legal aid that's held up the... Yes, it's legal aid that's held up the hearing of the appeal.
Yes. And that explains, that will also explain, I hope, to persuade my lords the reason as to why I made the points that I made 4 years ago before the Court of Appeal. So at paragraph 27 of the judgment, my lords and my lady will see a summary of the grounds, and you'll see how the first ground is expressed. The tribunal's approach was inconsistent with Januzzi, and the findings were inadequate.
Can I just interrupt? Just in case any of you are not aware of this, the court is perfectly willing to write to the legal aid authorities in a case of this kind, where there are obviously a large number of other cases piled up behind it to try to unblock the logjam. So if you have a similar appeal in the future, that's something that can be borne in mind.
Okay. Now, you'll then see, this is paragraph 28, two issues concerning the first ground. And you will see that the first issue had nothing to do with the criminal conduct. It was an attack on the reasoning of the tribunal, and that is issue B before the court now. And the second issue was whether criminality is relevant to the reasonableness of relocation. There is a discussion about the first issue. I'll come back to that when I address you on the second issue at paragraphs 29 to 36, and then see paragraph 37. And you'll see the word also that appears in the first line. So that was an additional argument that I pursued before the court. The reasoning is at paragraphs 39 and 40. Miller and Friend, of course, focuses on paragraph 40 in particular, the first and the second sentence. But I do invite my lords to consider paragraph 39 first, because it provides the context and the background in which the observation at paragraph 40 is made. You'll see that in the very first sentence at paragraph 39, the court said that a person's criminal conduct is relevant, but added that it may, of course, be a factor of no weight given the broad circumstances that are relevant. And if you look at the last sentence of that particular paragraph, you'll see that the court emphasized what I did not assert before the court, namely that ill treatment imposed on a person falls short of ill treatment because of the person's criminal conviction. You then look at paragraph 40. Now, in my respectful submission, a proper reading of paragraph 40 in the context is that the court was not calling for a moral judgment as to a person's criminal conduct. This is not what the court said. The court used the phrase value judgment, not a moral judgment. In my submission, it contemplates the decision maker evaluating all the circumstances relating to an individual and exercise a judgment as to whether they can reasonably be expected to relocate.
So a multifactorial judgment, as it were.
Yes. Yes. So the submission is that the evaluation, evaluation of fact involves consideration of a person's criminal conduct, and value, I emphasize, is not a moral judgment. If the court meant what Miller and Friend says it meant, one would have expected it to have said, would have referred to moral judgment at paragraph 40 as opposed to a value judgment. It did not say that it was altering the standard to be met. The Court of Appeal did not say that a person's criminal conduct alters the standard of harshness, or criminals are expected to suffer more or tolerate to a greater degree of harshness.
Can I ask you, Mr. Malik, about two matters? The first is, you see how in the first sentence the court framed the question, is it unduly harsh to make SC move? And then they say the phrase unduly harsh imports a value judgment of what is due to the person.
Yes.
Now, as you just said a moment ago, the test under Rule 3390 is actually whether the person could reasonably be expected to relocate. And that's also, that implements the identical obligation under the Qualification Directive. And I suppose you would say that the satisfaction of that test would also be consistent with the approach of the Court of Human Rights in talking about whether it's reasonable or viable, whether internal relocation is a viable alternative. So can we put to one side the question of undue harshness as a formulation in this context?
Well, I think the case below proceeded on the basis that if internal relocation is not unduly harsh, it will not be unreasonable. And that is the test that one gets from Januzaj. But I'm entirely
but Januzaj is a case simply to do with the interpretation of a refugee convention, looking at it without any consideration of the qualification directive or the current immigration rules.
Yes, I've no difficulty with that. The answer to my Lord's question is that I'm entirely content for the court to avoid the language of undue harshness and instead to use the language that is of reasonableness.
What is reasonable, right? Okay.
Yes.
The second question I was going to ask really follows on from that. That having said that the phrase unduly harsh imports a value judgment of what is due to the person,
yes,
the court then says it's possible to postulate that what may be an unduly harsh consequence for one person may not be an undually harsh consequence for another person, where the latter is a person who represents a danger to the community because he's committed serious offences. Now, if I'm following your submissions correctly, you're not putting forward that position. You're rather, if I'm following it, you're rather saying that whether a person can reasonably be expected to relocate will depend on a variety of circumstances, including the personal, it may be aspects of the character of the person concerned, and that his history of offending may have a bearing on that assessment of his capabilities, if you like, and in that light, whether he is somebody who could reasonably be expected to relocate.
That is my submission, and that is the only submission that I advanced before this court. But I do with respect add this, that this submission is in fact on analysis not inconsistent with this particular sentence at paragraph 40 of the Court of Appeal's judgment, because you read that sentence with paragraph 39, where the court said that a person's criminal conduct may be a factor of no weight. If at paragraph 40, the court wanted to set a test, so to impose a moral judgment as to a person's crime, why would it say at paragraph 39 that it may be a factor of no weight? Because when it comes to a moral judgment, a person's criminal conduct can never be a factor of no weight. It can only be a factor of no weight in an assessment, an evaluative assessment of all the facts that I seek to put forward.
Has paragraph 40 been relied upon in other cases to import a wider test?
No, that is one of the points that I wanted to address the court on. No court or tribunal, in my knowledge, has read this judgment in the way that Miller and Friends for the appellants have read it. This case was decided in 2017. If the upper tribunal or the first-year tribunal, the High Court or the Court of Appeal, had understood this judgment to have altering the standard of harshness, one would have expected another court or tribunal to have said so and followed that reading of this judgment. I'm not aware of any authority. I doubt if Miller and Friend is aware of any. If there was any, one would have expected the appellants to have provided it.
Danger to the community might tend to suggest, to support Mr. Hussain's reading of it rather than yours, might it not? This is not saying he has those characteristics of resilience which would enable him to survive in harsh circumstances. This is closer to a moral judgment.
I accept that. If one focuses on that sentence, the way in which the sentence concludes, I accept that is a possible reading. And that is why I ask my Lord, with respect to consider reading that paragraph with paragraph 39. And the submission is that if the court wanted to impose a requirement of moral judgment, it would have said so. Of course, the court used the word value judgment, but my submission is that it's another way of saying that there should be a factual assessment of all relevant circumstances. My Lord, the President, of course, picked the word due, and that is what is stated in the third line, due to the person. My submission is that when the court used that word, it simply meant what is suitable to the person as opposed to what that person deserves. That is how I invite the court to read paragraph 40. But if the court is not with me, and if the court takes the view that there is an ambiguity in the judgment, I'm very happy for the court to make it absolutely clear that criminal conduct is relevant only in the sense that I put forward. I'm entirely happy for the court to do so.
Now, if then the appellant's history of offending is only potentially relevant insofar as it demonstrates personal characteristics which would affect a judgment of whether he could reasonably be expected to relocate. Was his history of offending analysed before the tribunal with that in mind, and with a view to the tribunal making any findings of fact about relevant aspects of his character?
When the first-year tribunal made its original decision, it did not consider the appellant's criminal conduct in that sense, made no findings. That with respect, is my complaint. That failure to make findings on that point means that there is an error of law, the matter should go back. And if you look at paragraph 41 of the Court of Appeal's judgment, you'll see the concerns that the court has expressed. Now, if you look at page EF 150, you'll see that the court referred to a useful structure, which firstly a decision maker should set out factors pointing towards internal relocation being unreasonable or unduly harsh, and then list of those factors pointing against that conclusion, and there should then be an evaluative exercise and a conclusion. So it's unclear, I submit, from the first-year tribunal's decision as to what it did or did not consider, and that is one of the reasons why the court found an error of law and remitted the matter for a fresh hearing.
Obviously, you and your junior were not didn't appear before the first-year tribunal.
No.
Was the Secretary of State's case put in this way?
No.
Was the tribunal invited to make any?
No. I mean, of course, this point, the point about the criminal conduct was taken at the Court of Appeal level. The Court of Appeal entertained the point, took no issue with the fact that it wasn't taken below. The Court of Appeal has jurisdiction, it's uncontroversial, to allow points that were not taken below. And this is one of the points that was allowed by the Court of Appeal to be taken on appeal for the first time. But this isn't a point that was made before the first-year tribunal. I accept that.
I could take you back to the concession you made about the lack of undue harshness in Rule 339 naught. If there is no undue harshness, then is it no longer a stringent or a rigorous test?
No, because the test of reasonableness is akin, in my respectful submission, to unduly harsh test. I said that I'm entirely happy for the court not to use the language of undue harshness, but that does not mean that the test becomes less stringent. is still, in my respectful submission, take into account all the relevant factors, adopt the approach in Genuzi and AH Sudan, and decide whether it's reasonable or unreasonable.
But it's
expectation.
Unduly harsh because of the comparison. Sorry, it's a rigorous test because of the comparison between unduly harsh and reasonable. And it can't be reasonable if it's unduly harsh. And but you're content to leave out the word unduly harsh, and I'm not certain how that ends up then.
Because the rule itself does not use the word unduly harsh; it uses the word reasonable, and I'm content for the court to proceed on that basis. But my submission is that internal relocation is unreasonable only if it's unduly harsh. That's what was said in Genuzi and AH Sudan, and I respectfully maintain that position. Well, given that it's now common ground.
Sorry for asking these questions. Yeah. But is that test exactly the same as the European Court of Human Rights test of viable? I mean, if you have a test under the immigration rules, is it the same test or a different test from the one expanded by the European Court of Human Rights? Which test should we apply?
Lord, the test that the court will apply is the test in paragraph 3990 of the immigration rules, because of the concession that I made and the concession that was made before the tribunals and the court below, and it's common ground that is the test that this court would apply as opposed to any other test. And in relation to that test, the relevant authorities, again, it's common ground, are Genuzi and AH Sudan.
I'm just thinking aloud, Mr. Malik, but I'm wondering whether you know that the test in Rule 3390 is in identical terms to the qualification directive.
Yes.
And at the time that we are looking at, which was obviously before this country left the EU, the highest norm, if you like, would have been the requirement under the European Communities Act to give effect to EU law. And I suppose the Human Rights Act would have to rank below that if there was a conflict, but one would try. I mean, the EU law itself will be intended to be compatible with the Charter on Fundamental Rights, and I dare say with the ECHR, and so one would be aiming to avoid any conflict between the two. If anything, the EU test might be thought to have been expressed at least consistently in the same language, reasonably be expected, whereas we've seen the EU test is sometimes put in different ways in different cases. You sometimes talk about it being reasonable, sometimes you talk about it being viable. I don't imagine there's any difference in substance intended between those words.
Well, my submission would be that there isn't a difference. But of course, for my part, I'm sure the court will understand my reluctance to say much about the European authorities because of the concession that I have made. Yes. I have accepted that paragraph 3990 applies to this case, and I respectfully invite the court to proceed on that basis. Now, my learned friend took the court to a skeleton argument that I drafted 6 years ago. That skeleton argument is in the additional bundle, EF 2516, and you will see that skeleton I drafted on 4th of January 2016. Lords and Milady will recall that my learned friend took you to page 2526. Now, you'll see that 6 years ago there was a genuine uncertainty as to the meaning of unduly harsh and its relation to the public interest. There were two conflicting authorities at the upper tribunal level. The first authority was MAB, which I referred at paragraph 28, and the second authority was KMO, which I referred at paragraph 30. I then made a submission that the court should approve KMO and conclude that MAB was wrongly decided. And of course, I do not shy away from the fact that I did make the submission that I made at paragraph 27 based on the public interest. But that was the submission that I made in 2016 based on the case law that was then available to me. In 2017, the uncertainty settled to some extent with the judgment of the Court of Appeal in Uganda. So this was my permission skeleton. I then drafted an appeal skeleton and dropped these points, dropped the point that I've made at paragraphs 27 to paragraph 33. The appeal skeleton that I drafted 4 years ago is in part 2 of appendix, and it is at page EF 606. Now, you see that skeleton I drafted on 17th of October 2017. And if you look at the submissions on internal relocation, they are at page 615 to 616, paragraphs 20 to 25. And you'll see that I abandoned the point, I dropped the point about the conflict between MAB and KMO. But the submission that I made in that skeleton argument was a submission that was arguable when I made it in 2017. At that point, there was still a conflict of authority at the Court of Appeal level. There were two irreconcilable judgments, Uganda and MA Pakistan, one suggesting that public interest is relevant, the other suggesting public interest is irrelevant. And that is the context in which I made those submissions. My learned friend also asked you to look at paragraph 37 of the judgment. This is paragraph, page EF 622. I made a submission about the very significant obstacles test. I invited the court to find that criminal history is relevant, and I relied on the law as I understood it at that time, as set out in Uganda. Now that was in 2017. In 2018, I mean one year after I drafted that skeleton, this court said that Uganda was wrongly decided. So I do not want the court to proceed on the basis that I was simply making hopeless points all along and then ultimately drop those points before this court.
It's relevant to how one interprets the Court of Appeal's judgment. How you put your case at that time.
Yes, I accept that. But what I had demonstrated by taking you to the two skeletons is that I dropped the point about the public interest altogether in my replacement skeleton, and made other points, namely that the criminal conduct is relevant. But anyway, I mean, what I submitted before the Court of Appeal is not really relevant. I mean, what is relevant is what the Court of Appeal has actually said. And if as I said, there is an ambiguity in the Court of Appeal's judgment, this court can clarify that ambiguity and clarify that public interest is only relevant in the way that I say. Now, given that it's common ground that criminal conduct is relevant in an assessment as to whether internal relocation is in fact reasonable, I mean, I do not propose to make any lengthy submissions on it. You have my submissions based on case law on that issue in my written case, paragraphs 26 to 48. And I say that the concession that my learned friend made was a correct concession, entirely consistent with the case law that I've referred in my skeleton. So moving on to the second issue, may I make three very short propositions of law, and will then make brief submissions on the first-year tribunal's decision. So three propositions. First, the test of reasonableness in paragraph 3990 of the immigration rules is a stringent and very rigorous test. Stringent is the word that Lady Hale used in A.H. Sudan at paragraph 22, EF page 838. Very rigorous is the phrase Lord Hope used at paragraph 53 of the judgment. In that case, page EF 821, Lord Gospel used the phrase rigorous at paragraph 27, page EF 826. So the fact that it's a stringent and very rigorous test is unsurprising. The internal relocation must be unreasonable, not uncomfortable, or not merely harsh, which in itself is a strong word, but unduly harsh. The second proposition that I respectfully advance is that.
Oh, well, I'm sorry. Yes. I've just found the passage in Lady Hale's speech on it's page 838, paragraph 22, and she's saying, well, she says that although the test of reasonableness is a stringent one, whether it would be unduly harsh to expect the claimant to return, it's not to be equated with a real risk of a breach of Article 3. So, I mean, this is another refugee convention case, and she's using the unduly harsh test that we saw developed in that context before the qualification directive came along.
Yes. Of course, the observation is that it's a stringent test, but not as high as Article 3, but it's nevertheless a stringent test. And if you're looking at the judgment, then respectfully invite you to also look at paragraph 50. This is the only paragraph that is relevant in this judgment. Behind tab 12, EF page 788, you have Januzzi.
Yep.
And the relevant paragraphs are 53 and 67. The second proposition is that the objective of internal relocation alternative, whether it's under the Refugee Convention, the Qualification Directive, or the European Convention on Human Rights, is not to ensure that an applicant is able to live a completely normal life on return or enjoy the rights and facilities that they enjoy in the United Kingdom. As long as they are able to live a relatively normal life in a less hostile part of their country, judged by the standards that prevail in that country, the test would not be met. This comes from Januzzi, paragraphs 19 and 20. You have those paragraphs at EF 809 and 810. and you'll see the phrase relatively normal life at page EF810, just against letter D. And I do invite my lords and my lady to consider the example that Lord Bingham gave at paragraph 19 of the judgment. I refer to that example in my written case as well. And I do invite my lords and my lady to have that example in mind when you consider my submissions on what the first year tribunal actually decided. And then relevant to this proposition is also paragraph 47. This is Lord Hope, page EF819. This right at the end of that page, after letter H. If the claimant can live a relatively normal life, judged by the standards that prevail in that country, and you'll see a reference to less hostile part, not a completely normal life, a part that is completely safe in the sense that there is a complete immunity, but a part that is less hostile. The third and final proposition is that so far as the third proposition is that so far as the economic difficulties are concerned, what an applicant must demonstrate in order to succeed is that there is no real possibility of economic survival in the country of return. And in that context, among other things, the decision maker should consider the possibility of financial assistance from family and friends in the United Kingdom. The authority for that proposition is genocide. May I take my lords, my lady, to page 811, EF811, just above paragraph 21. You will see that Lord Bingham referred to a commentary by Mr. Story. And if you look at the text just against letter E, what must be shown, I emphasize the word must, to be lacking is the real possibility to survive economically given the particular circumstances. And in deciding that, the decision maker must take into account all the relevant factors and then see the very last bit in that passage, that in that context, the possibility of avoidance of destitution by means of financial assistance, whether from relatives and friends or even governmental or non-governmental sources, cannot be excluded. So that too is legally relevant.
Does that involve a burden and standard of proof?
No. This is one of
a factor to be taken into account.
Yes.
So far as the economic difficulties are concerned, the applicant must demonstrate. You mean it must be demonstrated, not necessarily by the applicant, but it must be apparent to the tribunal.
I accept that. Yes, learned friend is correct in saying that no burden or standard of proof arises, but that is what the decision maker must consider, must decide. So with these three propositions in mind, if I may then make some very brief submissions on the first year tribunal's decision. And that decision is in core volume EF page 165. There is only one paragraph in that decision that addresses the internal relocation alternative, and that is paragraph 52. No, sorry, it's
38.
not paragraph 52. I'm very grateful. It's 38. It's EF, page 172. Now, you'll see that the tribunal took the view that it wasn't reasonable to expect the appellant to relocate for 4 specific reasons. First, the appellant's links were only in Kingston, and the mother and grandparents have moved on. Second, the appellant has not lived in Jamaica since 2001, visited that country, or has been in contact. Third, he needs long-term psychological treatment. And fourth, that he would have to move to a rural location to avoid the general population, and he would be unsupported, homeless, destitute, unemployed. The Court of Appeal gave 4 reasons for concluding that this was insufficient. Those reasons are set out at paragraphs 35 to 40 and 41 of the Court's judgment. There was no consideration by the tribunal of any part of Jamaica other than Kingston, and no analysis of the risk across different cities. There is a reference to long-term psychological treatment, but no analysis of whether that treatment can continue in Jamaica, no analysis of any evidence about the medical facilities in any part of Jamaica. Thirdly, the finding as to the lack of employment opportunities is without any evidential foundation. No evidential source is identified. And it's unclear from this paragraph as to what the first-year tribunal weighed in balance in its consideration. So these, of course, are factors that may tell in favor of internal relocation being unduly harsh or unreasonable, but it's not clear whether the tribunal took account of factors that point to the opposite direction, demonstrate that relocation would not be unduly harsh or unreasonable. And for these 4 reasons, I respectfully submit that the conclusion reached by the court was plainly correct. Now, if the court takes the view that these 4 reasons are not enough, I have 4 further reasons as to why the conclusion at paragraph 34 is wrong in law. And may I make those 4 points very quickly. The first point, my lord, is the first additional point is that at the end of paragraph 38, you'll see a finding that the appellant will have to avoid general population. Now, there is no explanation as to why the appellant would be avoiding general population. His mother's appeal was allowed because she faced risk from gang members in Kingston for being lesbian. There was no issue. Even in the mother's appeal, her case wasn't that she was at risk at the hands of general population. Her claim was specific about gang members. But of course, the position now is different. The mother is in the United Kingdom. When the appellant returns to Jamaica, no one, respectfully invite the court to consider, would anyone be able to establish the link with the mother, given that the appellant has not lived in that country since 2001? There's no question of mother's return to Jamaica, and no explanation as to why the appellant would avoid general population if the finding is that a family member of a lesbian living abroad is at risk from general population, then that finding is simply perverse. It's without evidential foundation. Secondly, within that paragraph, you'll see a finding that the appellant is deeply traumatized and is in need of long-term psychological treatment. I accept that is what the evidence showed, but it does not follow that treatment should be undertaken in the United Kingdom. And on this point, I respectfully invite my lady and my lords to recall the example that Lord Bingham gave in Janazah at paragraph 19, the example that I just asked the court to consider. Of course, the facilities that the appellant enjoys in the United Kingdom would not be the facilities that the appellant would have access to in Jamaica. But that disparity in the treatment is irrelevant when it comes to the question of internal relocation. So that's the second point. The third point is directed to the tribunal's finding that the appellant would be unspotted, homeless, or destitute. There's no reasoning as to why that is so. There was no evidential basis for the tribunal to make that assumption. It was not suggested in the evidence that the appellant was not fit to work. Well, in fact, in the evidence, the appellant stated that he had completed various vocational courses in prison and was hopeful to get an employment. He was actively looking for work. This is what he said in evidence, and was working and felt much stronger. If you look at paragraph 58 of my written case, EF page number 115, you'll see the references to the appendix part 2 of the witness statement from where I make this submission, and I've quoted the evidence. And there was also evidence before the tribunal in the form of the statements that the appellant was receiving pocket money from the mother and the surety. And one witness said that he was willing to help the appellant as much as he could. And to that evidence, I invite my lady and lords to consider the point that I made about the economic survival. It's just impossible to see how, in that context, it can be said that the appellant would be unspotted, homeless, or destitute, unemployed on return. No assessment of whether there is a real risk that the appellant would not economically survive. The fourth and final point is directed to the finding that the appellant will have to move to a rural location in order to avoid general population. There's no explanation as to why general population in urban areas is considered to be more hostile than rural. So that finding is inadequately reasoned, not supported by evidence. These are 8 reasons as to why paragraph 38 of the first-year tribunal's decision is simply an inadequate and legally flawed consideration of the internal relocation option. Now, in response to this submission, Miller and Friend asks the court to look at paragraphs 33 to 37 of the first-year tribunal's decision.
Let's have a 1 minute break.
Yes, certainly, Mr. Hussain.
I apologise.
Yes, the court will adjourn for as long as you require.
I apologise. questions, sir.
Not at all.
So, my lords, lady, I identified 4 reasons that the Court of Appeal gave for concluding that this paragraph is wrong in law. I made 4 further points. I just wish to emphasize here that these are not new points as such. I made those points at the Court of Appeal level. They are in my skeleton argument. In my written case, I've given references to the paragraphs in the skeleton. So these points were made to the Court of Appeal. The Court of Appeal did not reject these points, but felt the first 4 points to be enough to conclude that remittal is justified. Now, my learned friend, in response to these 8 points, asked the Court to look at paragraphs 33 to 37. So may I deal with those paragraphs in the reverse order. So first, paragraph 37. This is the paragraph that is immediately above the paragraph in question. Now, this is where the tribunal is considering an entirely distinct question as to whether there is sufficiency of protection in Jamaica. It has nothing to do with internal relocation. So that paragraph does not assist the appellant. But in any event, there is an obvious difficulty with it. You'll see that the tribunal referred to SW Jamaica. This is the country guidance case. And the country guidance is that where a risk is established, where a real risk is established, the Jamaican state offers lesbians no sufficiency of protection. That I accept is the country guidance. But there is no explanation as to how the tribunal read that sentence into the conclusion that appears in the next sentence. In the next sentence, the judge concludes that well, this country guidance means that any attempts by the appellant to access state protection are likely to have the same negative outcome. This is not what the country guidance case said. There is no evidential foundation for that conclusion. Even if there was, it's not spelled out. The judge has not explained the reasons behind that finding.
Well, we were directed to the adjudicator's ruling.
Yes. So
in the other matter.
Yes. So lady, if you look at the adjudicator's finding, that decision, milady, is at EF 178, and the relevant finding is at paragraph 39. There's no issue with that finding. Things have not changed. There is not a sufficient and effective protection for this social group. This social group is lesbians residing in Jamaica, not family member of a lesbian who resides in the United Kingdom. But in any event, at paragraph 37, the judge did not say that she was making that finding on the basis of what the adjudicator had decided. There's nothing in paragraph 37 that undermines the submissions that I've made. Then see paragraph 36. This is where the judge accepted that there is, on a lower standard of proof, a real risk of ill treatment. But there can be no doubt that finding is about Kingston, not Jamaica as a whole. Because if that finding is about Jamaica as a whole, the question as to internal relocation becomes moot. Because that question only arises where there is a safe place. Then see paragraph 35. So this is where the judge referred to objective evidence. But this relates to the question of risk in Kingston, not relevant to the question of internal relocation to another part. But I do invite my lords and my lady to look at the examples that are given from the objective evidence. They demonstrate that that criminals targeted gay community in particular in Jamaica, and family members were also targeted. But those are instances, evidently, as clear from paragraph 35, where the principal victim was residing in Jamaica. Here, the mother is in the United Kingdom. There's no question of return. No evidence is cited for the conclusion that a family member of a lesbian who resides in the United Kingdom will be at risk in Jamaica simply for that reason. So those references do not justify the finding that appears thereafter.
Do you accept that if a lesbian does reside in Jamaica, that the family members are also at risk?
Well, I do not say that in every case every family member would be at risk. The existing country guidance is that Jamaican state offers lesbians no sufficiency of protection. There is no country guidance decision that says that family members are also at risk simply for that reason. But in this case, in this case, given the findings, I would accept that if the position was that the mother would return to Jamaica, live with the appellant, then what is cited at paragraph 35 may justify the finding that the appellant would also be targeted.
That is referred to at another point in the decision.
Yes, no issue with that. But what I do not say is that every single family member of a lesbian in Jamaica would be at risk. That would be a matter, of course, for a country guidance decision. But on the facts of this case, I accept entirely what my lord has just said. Then paragraphs 33 and 34. This is where the judge said that the Secretary of State advanced no challenge to the adjudicator's decision of 2003 and in fact accepted that things have not changed. No difficulty with that. That decision held that the appellant's mother was at risk because she was lesbian and that there's no sufficiency of protection. But there's nothing, it does not follow that that Jamaican state offers no protection to straight men who are family members of non-resident lesbians. So no legitimate view that concession can lead to the conclusion that the tribunal has reached. So for these reasons, I submit that there's nothing at paragraphs 33 to 37 that undermines the submissions that I've made. Before I move to the fourth issue, may I just give my lords and my lady reference to paragraph 34 of the Court of Appeal's judgment. It's not relevant to this issue, it's actually relevant to the first issue, and may assist the court in relation to the questions that were put to me. Page EF 147. You'll see a reference to value judgment in that paragraph again. The third last line, the third question involves a further value judgment based on the evidence accepted, not a moral judgment, but a value judgment based on the evidence, which relates to a factual assessment. So moving on to the third issue. So this concerns, this issue has two limbs. The first is the limb, the subsection 4B limb, integration in the United Kingdom, and secondly, subsection 4C, the integration in Jamaica. So dealing with the first limb first, integration in the United Kingdom, can I make two very short propositions, and will then make submissions on the first year tribunal's decision. The first proposition is that membership of criminal gangs and persistent criminal conduct shows a lack of acceptance of United Kingdom values, including the principle of rule of law, and consequently it demonstrates lack of social and cultural integration in the United Kingdom.
Forgive me, are we now on section 117C of the 2002 Act?
Yes, we are. Yes.
Exception 1.
Exception 1, subsection 2B. There's no dispute about subsection 1A.
Thank you
so
very much.
2B, social and cultural integration in the United Kingdom. And the submission that I make is that membership of criminal gangs demonstrates lack of social and cultural integration. The authority for that proposition is the judgment of my Lord Hemblen in the case of Benbuga. May I take the court to that authority and will then make the second proposition. That authority is page 1677. This is where my Lord dealt directly with this particular provision in section 117C. And the relevant paragraphs are at page 1639. And may I respectfully ask my lords and my lady to consider paragraphs 56.
Sorry, the page again,
1693.
And 3, thank you.
This is the judgment in Benbuga, and paragraphs 56 to 59 make the point.
The first-tier tribunal judge does refer to this point, doesn't
Yes, indeed, Lord. May I just make the second point, and
Yes,
we'll then take you to the first-tier tribunal's decision. But I do ask Lords and Lady to take a note of paragraphs 56 to 59 and consider the reasoning of Lord Hemblen as to that issue, as to why persistent criminal conduct demonstrates lack of integration, and what is the purpose of this provision. So the second proposition, the second point is that financial independence is also an aspect of social and cultural integration in the United Kingdom. Financial dependency on others with no good reason shows lack of social and cultural integration. Now, I do not have an authority in support of that proposition, but my submission is that the concept of social and cultural integration is broad enough. It contemplates a person being able to contribute to the economic well-being of the society where he lives. And so with these two propositions in mind, may I then take you to the first-tier tribunal's decision and make some very brief submissions as to why I say that the assessment is legally flawed. So page EF 173 is where you will see one paragraph. There's one paragraph alone that deals with cultural and social integration in the United Kingdom, and that is paragraph 46. There are four very short points that I make about this paragraph. The first is that the judge erred in approach. She conflated the requirement of social and cultural integration with a justification for lack of social and cultural integration. I accept that it's possible to conclude that one of the reasons of the appellant's extensive criminal conduct is his past experience and the hardship. But that explains why he is not socially and culturally integrated. It is not a reason to conclude that he is in fact culturally and socially integrated. On the approach that Lord Justice Hamlin set out in Benbuga case, paragraphs 56 to 61, the only conclusion that was open to the judge was to find that this appellant is not culturally and socially integrated in the United Kingdom. That's not the end of the Article 8 analysis, I accept, but that means that the exception is not met. My Lord Justice Lloyd Jones was absolutely right that the judge did, in this paragraph, refer to the appellant's criminal conduct, but you'll see that in the last sentence, the judge conflated the requirement with the justification.
If in relation to financial dependency as an indicator of integration, you're allowed to take into account a disability that is actually suffered by an individual, explaining why that person doesn't work.
Absolutely.
Then why can't you do that more broadly in relation to other aspects of integration, so that one takes into account his personal circumstances as to why he hasn't achieved integration?
Well, because if a person is not working because of a disability, when I made my submission on financial dependency, Lord will recall that I qualified it by saying for no good reason. He is not committing a crime. He is not demonstrating a contempt for the rule of law or basic values of the United Kingdom. But when one is dealing with a persistent offender, by his persistent offending, he demonstrates a contempt for the rule of law. And as I said, that the past experience or conduct may justify that lack of cultural and social integration, but there is a different requirement. In my respectful submission, the judge was wrong to conflate the two here. Secondly, in this case, I accept that residence in the United Kingdom and schooling are all relevant matters when considering whether there is social and cultural integration. But in this case, for the reasons I've given, relying on Benbuga, on those factors could not have allowed the tribunal to conclude that there is, in fact, social and cultural integration. The fact, and this is the third point, the fact that there is no contact in Jamaica is simply irrelevant. That may be a relevant consideration to subsection 4C about integration in Jamaica, but the fact that there is no contact in Jamaica does not mean that the appellant is socially or culturally integrated. And fourth and final point is that there is no consideration at all by the judge as to the appellant's financial circumstances. There is a finding later on in the decision, paragraph 51, that the appellant is not financially independent, but no account was taken of that factor in the analysis at paragraph 46. So the judge conflated the requirement, erred in the approach, made a perverse decision, took into account relevant factors, failed to take into account relevant factors, and took account of irrelevant factors. And that means that paragraph 46 is wrong in law. Moving on to the second limb, subsection 4C, the proper approach to that subsection is now settled by this court in Sanambar. You have that authority at page 1671. May I ask my lords and ladies to look at page one?
I'm not sure that's the right reference. Did you say 1671?
Sorry, 1761. Lord,
right. I
apologize. So this is Sanambar. This is where the court deals directly with this section. And at paragraph 55 of the judgment, page 1774, you'll see that the court approved what Lord Justice Sales, as he then was, said in the case of Kamara, that it's a broad assessment, a broad evaluative judgment, and the question is whether the applicant will be enough of an insider in terms of understanding how the society in the other country operates, so to participate it, and have a reasonable opportunity to be accepted there and to build relationships. So that is the correct approach, the approach that I ask my lords and my lady to apply to the findings made by the tribunal below. And may I also ask my lords and my lady to look at paragraph 761 of this judgment, page 1776. So this is where Sir Declan Morgan said that a person's criminal conduct is relevant in the same sense that I have outlined in relation to issue 1. It may demonstrate a robustness of a person's character. I accept entirely that KO Nigeria says that there is no balancing exercise of the public interest, and I've made it clear that I do not pursue the point based on Uganda that I made at the Court of Appeal level, but the criminal conduct is relevant in that particular sense as contemplated at 61. Just one further authority that I need to show you, and I show you that authority because that is where the Court of Appeal dealt with the observations in Kamara and considered what was meant by the broad evaluative judgment, and that is the Court of Appeal's judgment in AS Iran. You have it at page 1663. And the only paragraph that I highlight is paragraph 59 of the judgment. You have that paragraph at page 1675. So this is where the court deals with the phrase enough of an insider and rejected the submission, in my submission correctly, that is solely to be determined by reference to ties or links in the other country. So the fact that a person has no links or ties with a particular country does not mean that he is not enough of an insider. The decision maker will have to look at the generic factors, how fit that person is to work, to adjust, and so on and so forth. So with this approach in mind, if I may just respectfully take you back to the first year tribunal's decision to see how it dealt with this particular subsection. The relevant paragraph is paragraph 47. You have that paragraph at page EF page 173. In my submission, this paragraph is inconsistent with the two authorities that I've shown you. There's no consideration of whether the appellant has the capacity to participate in Jamaican society. The fact that he has no contact, as demonstrated by reference to AS Iran, is not enough. No consideration of the relevance of the appellant's persistent offending, not in the sense that there is a balancing exercise of the public interest, but whether it demonstrates anything as to his character. And thirdly, true it is that he is traumatized and in need for long-term treatment, but no assessment at all as to why that treatment cannot continue in Jamaica. No assessment of any evidence about facilities that are available in Jamaica. So for these reasons, the first year tribunal's approach was simply unsustainable.
And your submission is that exception 1 doesn't apply because of those two
Yes.
conditions not being met.
Yes.
Is there a safety net?
There is, yes, of course. That is issue 4. And there is safety net because of what Lord Justice Jackson said in NA Pakistan.
And
There is, Lord Justice Jackson said, a drafting error
you accept there was a drafting error?
in the legislation, yes. And Mr. Robin Tam, QC for the Secretary of State, has already accepted that categorically in NA Pakistan. And I do not say that he was wrong with respect. If you need a reference to where he made that concession, it's NA Pakistan. I think it's paragraph 28, EF 866. Just double check that.
Thank you very much indeed. Thank you.
It's paragraph 21.
Paragraph.
Paragraph 21 of NA Pakistan, EF page 880, Mr. Tam QC for the Secretary of State accepted that the approach in JZ Zambia was correct. And that approach is set out at paragraph 20, includes the comment that a literal reading of the rules would result in bizarre circumstances. So that is the concession that was made by the Secretary of State, and I do not go beyond that concession. So two very short points about the safety net before I make submissions as to.
Well, you really just have to give us the bullet points because we're going to have to let Mr. Hussain have an opportunity to reply.
Absolutely. So in just two bullet points, these are propositions. First, in cases where the exceptions do not apply, the public interest will require deportation unless there are very, very compelling circumstances, that's the test, over and above those described in the exceptions. And that is determinative of the balancing exercise. There is no room for any additional separate or freestanding assessment. The authority for that proposition is NEA, the judgment of Lord Justice Richards, EF page 1644, paragraph 15, which is at page EF 1652. Second, in considering whether there are such very compelling circumstances, very great weight should be attached to the legislative policy. And that means that in general, only a claim which is very strong or very compelling will succeed. The authority for that proposition is NA Pakistan, paragraphs 12 to 22, EF pages 877 and 800, and the judgment of my Lord Reed in the case of Ali, paragraph 50, EF page 1588. Ali was a case about the rules, but what my Lord said applies with greater force to the statutory scheme.
Sorry, the references to NA Pakistan again, paragraphs 12 and...
12 and 22.
Thank you.
Now, given that I don't have much time, so instead of taking you to the decision by the first-year tribunal, may I simply give you the reference to my written case. And ask you, Lords and Lady, to look at what I've referred at paragraphs 84 to 86. So I quoted paragraphs from the first-year tribunal's decision, and the first point, and again, I'll give it in a bullet point format, is that the judge got the test wrong. You'll see that the judge did not consider whether there were very compelling circumstances, but whether there were any compelling circumstances. And you'll see that the judge made it very clear that she would not have allowed the appeal, but for the compelling circumstances, not very compelling circumstances. So the judge misdescribed the test and thereby attached little weight, not sufficient weight to the public interest. The judge referred to section 117C, but there is no finding that there are actually very compelling circumstances to relocation. The assessment is a freestanding assessment outside the framework of section 117C. Finally, you'll see that the judge balanced the offending against the traumatic history rather than statutory considerations. My lords have seen the Court of Appeal's judgment. You have my submissions on it in my written case. I do say that if one looks, the Court of Appeal dealt with section 117C under the same heading, so it dealt with subsections 4A, 4B, and the safety net together, and in that context referred to the test being misdescribed and the judge not giving sufficient weight to the public interest. So unless I can assist you any further, I think these are my submissions.
Thank you very much indeed, Mr. Marley.
I'm grateful.
Thank you. Thank you. As well. I've done this. My lords, my lady, may I respond? May I reply at seriatim as far as the main points are concerned? Criminal offending post-dating the Court of Appeal could be considered, Mr. Malik said, on remittal. That's a benefit of remittal. Obviously, that is contingent on demonstrating a legal error. Mm-hmm. And he does not, accepts he can't deploy that to demonstrate the legal error. So we would rhetorically ask, what is the point for which it is put before you? Issue A, Malone French says that criminality sheds light on survival capacity's robustness. 3 points. Never argued before any court or tribunal, not in the Secretary of State's decision letter, not in any argument before the FTT, not in any grounds to the UT, not in Mr. Malik's skeleton before the Court of Appeal. He was not able to and cannot point to a single sentence in any of his skeletons before the Court of Appeal where he says, look, the error that the FTT made was not to factor in robustness of character. It's not there. Why is it not there? Because the finding of the FTT impliedly was that this is a broken man, despite appearances. Indeed, third point, it would have been perverse to find that his offending showed a robustness of character sufficient in Jamaica, the site of the torture, the atrocity, to enable relocation to be reasonable. On the legal test, my lords, my lady, there are 2 cases we are aware of which have interpreted the Court of Appeal as we say it should be interpreted. Indeed, in the obvious way it should be interpreted, in the way Mr. Malik was arguing for. I don't mean to point to his skeletons by way of criticism, but as my Lord Hampden said, it explains what the court found. And it's telling that today The Secretary of State does not defend that for a second. There is no defence to it. Two cases, one in the Court of Appeal that stayed behind this case, another case in the tribunal. 6 points on the Court of Appeal. One, para 37 turned into Mr. Malik's submission that the consequence is turned into something. The same consequence is turned into. 39, that is picked up. It provides context, as Mr. Malik said. Yes, it does. You've got the same language, which conspicuously he did not read. He did not read the sentence in the Court of Appeal, where at 39 they say turned into. Third point, paragraph 40. As to what is due, a value judgment, Mr. Malik's submission, the words after value judgment of what is due to the person are redundant. For Mr. Malik's submission to work, the court should not have said of what is due to the person. It doesn't matter whether you dress that up as a moral judgment or a legal judgment. The point, it's very clear what's happening there. The standard is being elevated. Fourth point, paragraph 40, the final clause in the first sentence. Because the Court of Appeal accepted Mr. Malik's submission, it thought that it was relevant to the analysis what the cost would be to the UK of letting this man stay. Hence the clause, rather than letting him stay in the UK. Fifth point, my Lord Lloyd Jones. Why refer to danger to the community in paragraph 40? Sixth point, 41, blame. The focus on blame. Blameworthiness, what is due. Again, that indicates that the court held what we say it held, what Mr. Malik was arguing for. And here it's saying in 41, actually, we're not sure whether that would elevate the standard because he's not really to blame, or his culpability is reduced by reason of the atrocity that he suffered. My Lord the President, hierarchy, I think I would accept that because of supremacy at the relevant time, even now subject to this court departing, the qualification directive and the transposing matter would have priority. It's an interesting question. You don't need to get into it, whether or not the Refugee Convention, because they're not the same thing, the Qualification Directive and the Refugee Convention. There was a referred question, Lord Kerr, in a case called FA Iraq, referred a question to Luxembourg, a case called FA Iraq, about this, and Secretary settled the case. It's an interesting question whether the Refugee Convention is equally number one in the hierarchy, because EU law competence to legislate on asylum has to be consistent with Geneva. That's Article 78 of the Lisbon Treaty. But certainly it has a higher rank, we would say, than the ECHR. And if there is any difference between the tests, then it is the QD test that falls to be applied. And we can certainly read viable as reasonable, as my Lord said. Multifactorial, Lady Arden. I'm not making a concession about that, as my learned friend said. It's always been our case that you look at everything to determine impact. If you look at paragraph 47 of our case, it couldn't be clearer. We have always said you look at I'm not making a concession that criminality is relevant to this. It's my learned friend who's making the concession that criminality is irrelevant to the standard. Lord Reid, Lord Bingham does refer, just for your note, to the Qualification Directive in Januzzi. The reference is paragraph 17, EF 809. But we agree with you, if I may say so, my Lord, the test ought to be reasonableness. And then the points on the facts. So I addressed the Court of Appeal's criticism of the FDT's internal relocation finding before. The further points that my learned friend makes. Firstly, this wasn't a risk from the general population, it was a risk from gangs. Can I please take you to the UNHCR letter, which cites the Secretary of State's own material, and then I'm going to take you to her material. UNHCR letter is at electronic 188. So this is them, the UN, being given notice of an intended cessation and saying, don't invoke cessation. The Secretary of State then does invoke cessation. But can I please take you to 189, bottom of the page. UNHCR notes, if my lords, my lady have it, UNHCR notes that in the UK Home Office operational guidance on Jamaica, it is noted that Jamaica has a reputation for having an aggressive homophobic culture on top of its extremely high crime murder rate. Same report, this violence created a climate of fear that's prompted many gay persons to emigrate. While the gross indecency laws leave those who remain vulnerable to extortion from neighbours who threaten to report them, etc. Same report further notes that if there is a real risk that a gay man, lesbian, or those perceived as such, has or will become known. My client, with absolutely tragic consequences, did become known as the son of a lesbian. The applicant would, on return to Jamaica, face a real risk of discrimination, violence by members of the public or criminal gangs. That's my learned friend's material, to the extent that this would amount to persecution. UNHCR notes that according to the UK Home Office's own guidance, gay, lesbian, bisexual people suffer persecution because of sexuality. Given that SC hasn't lived since he was 10 years old, he would likely to have to return to rely on previously established networks, which will most likely include individuals, not gang members, individuals who are aware of his mother's sexuality. And then protection. Home Office recognises that there's a real risk of discrimination and violence amounting to persecution exists, not only for those who are gay, who are perceived as such, together with the fact that stated in the same Home Office report, in general, the Jamaican authorities do not provide gay men, lesbians, or those perceived as such with effective protection. That's their material. And we have the submissions that we had. The point about treatment, I made the point, the issue in the case isn't about standards in Jamaica. Is it adequate? What would you have? He can't access it on the accepted findings in a very detailed report, the Crowd report. And that puts this case in a different category to the cases where you've got problems in facilities countrywide. Lord Bingham in Januzzi at paragraph 90. This is not that kind of case. Not a case of inferior socioeconomic rights, inferior medical provision, health. It's not that at all. This is a case, whatever you've got, he can't access it. He could be going to Germany. He can't access the treatment in that country because of what happened to him in that country. That's the finding. Mr. Malik says that the conclusion that it would be homeless and destitute and unsupported isn't properly open to the tribunal. We say it's an obvious inference from the medical evidence that was accepted in terms of fitness to work On return, he wouldn't be. That's the import of the medical evidence. The medical expert explained how there was hope for this man because he was struggling and was trying to make the best of what had happened to him. She commented on how much love there was in this man for his sister and for his children. She was struck by that. And so there was hope. Yes, he had done courses. You move him to Jamaica, my lords, my lady, things change. And Mr. Malik, with respect to him, does not engage with that at all. He doesn't engage with, I'm sorry to repeat, but the extremity of the language bears repetition, the catastrophic consequences for somebody with acute and chronic and complex PTSD of being returned to Jamaica. Rural location, Mr. Malik says, well, is the general population there less hostile? That's not the issue. The issue is just less of them. There's less people in the countryside. Against the context where even in the countryside, his mother was identified and ill-treated. And then this new point, sufficiency of protection, paragraph 61-63 of Miller and Friends' case. Not raised at any point below, not raised before the first-tier tribunal, where we could have adduced further evidence on the point. It's not a point of importance. Your lordships, your ladyship should decline to consider it. Without prejudice to that, I've already pointed to, Lady Arden observed, the fact that the adjudicator made a finding about insufficient protection, applying the Horvath standard, which Mr. Malik alights upon, and the Secretary of State's own material, which I've just referred to via the UNHCR report, does the same thing. Can I just quickly take that up? It's at EF 536. So EF 536, the conclusion at 3.7.15, LGBT persons are targeted for murder, attacks, corrective rape. In general, the authorities don't provide such persons or those perceived as such with effective protection. And over the page, so top of 537, if there's real risk that a gay man, lesbian, or those perceived as such has become well known, the applicant would, on return to Jamaica, face a real discrimination violence by members of the public or criminal gangs, should be granted asylum. And then at EF 529 to 30, you've got a sense of the extent of executive capture of the authorities by the gangs. And they explain that it's because of the drugs trade from Colombia to Miami. EF 529, criminal gang violence. Jamaica has extremely high rates of violent crime, high rates of gang-related violence fueled by money from drugs. 367, long-standing relationships between elected representatives and organised crime, in which criminal gangs guaranteed voter turnout in certain neighbourhoods in exchange for political favours and protection. Bottom of the page, 530, 369. Intelligence suggested there were 268 active gangs in Jamaica, a 5-fold increase in prevalence 10 years ago. There was abundant material here for the conclusions the FTT reached. 532, top of 532. Unless reasonably likely to be admitted into the witness protection program, a person targeted by an organised criminal clan, and my goodness, my client was targeted, will not normally receive effective protection. So, with great respect, the point is hopeless on its merits, and it shouldn't be run. Your Lordship shouldn't entertain it, is what I mean. Then, my Lords, just very quickly, integration. Binbuga, my Lord Hamblin. My Lord Hamblin was faced with a striking case where the FTT found that gang membership was a telling example of integration. He said, obviously that's not right. It's not conclusive, though. Criminality is not conclusive. My Lord said breaking the law may involve discontinuity. My learned friend's argument in this case, I invite you to look at the extremity of this case. He says the only conclusion is that this man was not integrated by reason of criminality, which is absolutely not the multifactorial approach, similar multifactorial approach here, that my lords, my lady, are required, the courts are required to undertake. And can I just invite you to look at the CI case? This is Lord Justice Leggett, as he then was.
You know, this isn't really the time for...
No, I'll just give you a reference.
New authorities. Yeah.
No, I'll just give you a reference. We have cited the relevant parts at EF 92, footnote 89, and the relevant paragraphs are 56, EF 966, 60 at EF 967. Unsurprisingly, he endorses my lord in Binbuga. At 62 at EF 968, he says it's hard to see how criminal offending and imprisonment could ordinarily by themselves, unless associated with the breakdown of relationships, destroy integration of someone whose entire social identity had been formed in the UK. The appellant there was here from the age of 1, but the point holds. At 77, EF 971, the judge ought to have asked whether, having regard to his upbringing, education, employment history, criminal offending and imprisonment, relationships with family and friends, lifestyle, and the other relevant factors, integration had been destroyed. You don't just go, criminality, you're out. What's the point of the exception, if that's the case? And at EF 972, paragraph 79, Lord Justice Leggett warns of the danger of double counting. If you over-focus on seriousness of offending and length of prison sentences, then you're double counting potentially, because this Parliament's already said the weight that's got to be allocated to that in its scheme. And then trauma, the next point was trauma. Mr. Malik says that confuses the reason for the lack of integration with the requirement for it. That's rather question-begging. Is there a lack of integration? That's the issue. The Court of Appeal was correct to reject that, as it correctly rejected the perversity argument based upon criminality. And the FDT's view was, as I said, criminality was at least partially the result of trauma rather than lack of integration, given his mother's presence here, his love for his little sister. And Lord Justice Ryder noted at 41, the blame paragraph, which I showed you, that trauma was partly to blame and he could be rehabilitated. The FTT found he could be rehabilitated. And this is a perfectly orthodox approach. I venture to suggest something that my Lord had in mind, Lord Hamblin. It's entirely consistent with Lord Justice Leggett, as he then was. Again, in terms of presence of schooling and relatives, none of these matters, Mr. Malik says, can lead to a finding of integration. He has a particularly close bond with his mother because of the intergenerational trauma they have experienced. That is the FTT at paragraph 63 EF 175. Lack of contact with Jamaica. It was relevant here because it showed he didn't have a foot in that camp. It can be relevant. It was relevant here. He didn't have a foot in Jamaica. FTT was entitled to take that into account. Financial independence, Lord Stevens, we concur, my Lord. Absolutely. Look at why he's not financially independent. That's integration. Very serious obstacles. But my friend says this is inconsistent with AS Iran and Sanam. It's the same case. AS Iran, well, Justice Moylan is Sanambar in this court, the two cases he took you to. Same point, robustness never argued at any point until we get here. Far too late, it's totally unavailable on the material. I made the point before lunch, my Lord Stevens. Mr. Declan Morgan's judgment begins where he talks about robustness, that the upper tribunal found that he had robustness. Where is the finding here, we rhetorically ask? It's not there. And the last thing I would say is just to point you to Lord Justice Leggett in CI at paragraph 177, where he said, given there was also evidence which actually wasn't accepted. Here we had the medical evidence accepted. In CI, the medical evidence that was provided, which said that removal would be catastrophic for that appellant. And in the context of very serious obstacles, Lord Justice Leggett said at 117, page 982, that the harshness of deportation would be magnified in that case to the extent it could be considered cruel by the evidence of the devastating impact. We have evidence accepted of a catastrophic impact that it would have upon that appellant's mental health. That is the position here. The conclusion on exception 1 is unassailable. Safety net, one thing, very compelling. The first tier does say that at paragraph 53, page 174. Those are my submissions. I'm sorry I've gone slightly over.
Thank you, Mr. Hussain. We're grateful to all counsel and those behind them for the submissions you've received. We'll now take time to consider them and to have our judgment in due course.
Thank you very much.